This video is for new business owners, people managers, and anyone who just needs a refresher on some key tips to help you avoid your employees seeking legal action against you. I want to start by telling you that 9 times out of 10, an employee does not sue you or file a legal charge because you've actually broken the law. Most of the time, they do this simply because they feel that they have been treated unfairly. And usually the reason they cite for feeling that way is not a violation of law. Here's the thing, filing legal charges is generally free. The employee doesn't have to have a great case. If they instead choose to talk to an attorney, the attorney may glaze over the reason that the employee gives them regarding the alleged unfair treatment because they know that none of those are illegal. But they might ask about things that may make you nervous. They may want to see the employee's pay stub to see if the employee has been paid properly, that overtime is correct, deductions aren't out of line. They might ask about their exempt status to determine if there's a problem with that. And sometimes they'll find something that is of concern. And now the PTO that you declined, which is the reason the employee sought counsel in the first place, turns into a class action wage and hour suit. And I'm being dramatic, but you get the picture. So if the number one reason that people sue you is because they feel they were not treated fairly, what's the best way to prevent that, aside from treating them fairly, which is obvious? You just have to be respectful. Treat them with dignity, especially during a termination process. Rein in your emotions. Don't get into an argument about what happened. Don't name call, don't demean them. Just take an it is what it is approach. No hard feelings. Let's part ways. Okay, now that you know the number one tip, let's dig into the areas of employment law that you should be aware of. Now, this is a massive topic, so please know this is not an exhaustive list, nor is it meant to be considered a comprehensive overview by any means. Just some of the most common pitfalls that I've seen employers fall trap to. So we are going to talk about at-will employment, wrongful termination, wage and hour, discrimination, sexual harassment, and leave laws. So let's start with at-will employment. Most employers believe the term at-will employment means that they can terminate for any reason at any time, and that's largely true. However, if you are terminating for a reason that is otherwise illegal, like discrimination or retaliation, this is still going to be a problem for you. Also, you should be aware of the impact to your unemployment payroll tax, the state unemployment tax, SUI, when you terminate without cause. Moving on to wrongful termination. This is the one that employees threaten the most. It's actually a fairly high legal standard to meet, but it can happen when you are firing them for refusing to lie in a legal investigation or firing them after they complain about an unsafe work environment, just as examples. When we work with clients on terminations, we always want to keep the reason for termination business related and for cause. This not only protects the company from legal claims, including wrongful termination, but also helps win unemployment claims by establishing reasons covered by each state's unemployment law definition for misconduct connected with work. Next up is wage and hour. Probably one of the easiest ways to get sued. I always caution our clients that when it comes to people's money, they need to be hyper vigilant about getting it right in the first place and then responding to complaints immediately. Some of the most common mistakes employers make in this area of the law are misclassifying employees as exempt from overtime, not paying overtime properly, unpaid breaks that are less than 20 minutes long, and improper deductions. Wage and hour is also the most common area of the law to see class action lawsuits filed, so it's a very big deal. All right, on to discrimination. Discrimination is prohibited by a little law called Title VII of the Civil Rights Act, and I'm being sarcastic when I refer to it as a little law. It's actually what I consider to be one of the biggest deal laws of all of them because it covers a plethora of prohibitions. It's not to be taken lightly. When it comes to discrimination, this law prohibits employers from treating employees differently based on certain characteristics, often referred to as protected classes. The bottom line is that you need to be sure you're treating your 35-year-old white male the same as your 45-year-old Hispanic female employee in the same position. There's much more to this, but if there was one takeaway, it would be to simply be consistent and fair with all of your employment practices, especially as they relate to race, age, and disability, because those are the most common charges. Sexual harassment. Probably, in my opinion, one of the easiest charges to prevent, because the most effective mitigation measure is to simply communicate your policy, investigate issues promptly and effectively, and take remedial action to stop the behavior. When you do those things, even if the harassment was occurring, you will nearly always either prevent a charge completely or dismantle it early in the process. When you do nothing, that's when you find yourself in the media with a 6 or 7 figure settlement. Finally, leave laws. One of the most complicated, misunderstood, and challenging areas of the law to navigate, again, in my opinion. While state laws and the FMLA, which is the Family Medical Leave Act, it's a federal law, those can be fairly straightforward. The ADA, which is the Americans with Disabilities Act, is the grayest of gray, where everything is on a case-by-case basis and statutory guidance is limited. The best course of action for these is to first consider state laws and the FMLA before you jump to any ADA conclusions, and take advantage of the procedural benefits afforded by those other laws. Usually they're pretty straightforward with what you need to do, including forms that you can provide. When it comes to the ADA, proceed with caution. Research like crazy and seek counsel before making any adverse employment decision. And just so you have a little bit more information about what is the ADA, generally, if you have any employee who is requesting any kind of accommodation based on a medical condition or an impairment of any kind, it's probably going to get you in that world of the ADA. Okay, there you have it. I have to tell you, recording videos like this are kind of difficult for me because I know I'm leaving out so much. There's so much about each of these areas of the law to tell you, and so much to know about even more areas of the law. And I just want to help all of you with all of it. And when I run out of answers, I want to refer you to a great employment law attorney. But we'll leave it at this for now, because sometimes just knowing to be concerned about something is enough. Having that instinct kick in when you know you should pause because you think that there's something that you need to know about this, that's invaluable. So I hope I can help with that.